going to introduce, I'm Howard Adelman, and I'm going to introduce the speakers. I'll just say a couple words in advance. One is, I attended a number of the sessions, and the quality of this conference has been extraordinary. The papers were all really good, and the participants at a very high level. And I have to congratulate the organizers and you people for putting on an excellent conference. Second point is you're in for a treat. You started with a keynote with Lord Waldron, and we have a wind-up with 4 excellent participants. First, they don't invite a member from the UNHCR just to speak to you. They made him work and share 3 of the sessions. And so a number of you may already have been introduced to Kees Wouters. He is the senior legal political advisor at the UNHCR and brings a wealth of experience from that position. And he will speak first, and in effect, he will set off the tone and the discussion on the topic. Our second speaker is, like Lord Waldron, one of the extraordinary lawyers from Canada who set precedents at the Supreme Court, particularly in the Kees case, won all kinds of recognition for her work, legal work for refugees, an outstanding solicitor on behalf of refugees, Jackman. The third treat is Dench, who I'd say if there was a study of NGOs and advocacy agencies in North America, not just Canada, she would be the most outstanding leader of such an organization. She is superb. The fourth representative is Justice O'Reilly. Justice O'Reilly served 10 years on the Supreme Court. He told me just beforehand that at the federal court, sorry. He couldn't be interviewed on the Supreme Court. 10 years, he told me just beforehand that its caseload, about 80% of the presentations that come to the court are about refugee cases. Of course, it isn't the percentage they hear, maybe a third or quarter. But it's a big bulk of their cases, and of those immigration refugee cases, most of them are refugee cases. So it's a big section of the work of the federal court. So we have a wealth of knowledge, a wealth of experience, a wealth of intelligence, and I look forward to hearing the panelists. We'll open with you.
Thank you, Howard. I almost feel threatened among all these experienced Canadian lawyers. Well, thank you first and foremost to the organizers, and James in particular, for inviting me to this conference. And I won't be presenting a paper, certainly not a paper that I've written, although I will speak about a few papers actually that were written for UNHCR. But I won't be presenting a paper. I will be introducing a topic, and it's maybe a bit ungrateful to do that at the last session, Friday afternoon. I understand you have a long weekend ahead of you, and then you have to listen to these experienced lawyers behind this table. Nonetheless, I hope it will be an interesting topic. It's a topic that's high on the agenda of UNHCR, and it's something that hopefully will lead to fruitful discussions this afternoon and in the months and years to come. On Wednesday evening, when my director, Volker Turk, Director of International Protection at UNHCR, gave his opening address, he introduced you to the theme that is the topic of this panel session already. He introduced you to the theme of indiscriminate violence and complex conflicts causing forced displacement. He mentioned the transformation in the way violence is occurring, with a strong correlation between state fragility and violence, and with private actors of violence gaining ground, often in the form of organized crime. And he ended his statement by stating that a proper application of the 1951 Refugee Convention needs to be reinvigorated to address the protection needs of people fleeing armed conflict and other situations of violence. Now, listening to Volker Turk and then reading the famous UNHCR handbook, There's a new edition out, yellow. If you look at paragraph 164 of the handbook, it reads, in contrast, persons compelled to leave their country of origin as a result of international or national armed conflicts are not normally considered refugees under the 1951 Convention or 1967 Protocol. Now, when the High Commissioner in 2010 organized his annual protection dialogue, the protection of people fleeing armed conflict and other situations of violence was identified as a protection gap. Following Mr. Turk's words of Wednesday, I would like to be a bit more precise than that and refer to it as an issue of proper interpretation and application of the 1951 Convention rather than a gap that exists in international law. Moreover, in case the 1951 Convention does not apply, extended definitions formulated in regional refugee law instruments may apply, or various forms of what we call complementary forms of protection developed under international human rights law or developed under regional legal frameworks may actually apply, or complementary forms of protection developed under national laws and policies. Mr. Turk also mentioned to you a project that UNHCR is currently undertaking to develop guidelines for the protection of people fleeing armed conflict and other situations of violence. And the aim of this project is to bring back the primacy of the 1951 Convention and to do away with the statement I just read out of paragraph 164 of the handbook. We want to bring back the primacy of the 1951 Convention in addressing the protection needs of people being displaced cross-border as a result of conflict situations or other situations of violence, and to show that in many situations where people flee conflict and violence, the refugee definition is applicable because the violence is occurring, because the violence occurring is often discriminate rather than indiscriminate. And in situations where the violence is truly indiscriminate, use should be made of extended definitions of a refugee, such as mentioned in the 1969 OAU Convention in Africa and the 1984 Cartagena Declaration in Latin America. But when we talk about armed conflict or other situations of violence, what do we mean? And is it actually useful to qualify or classify violent situations as armed conflicts, or, as is sometimes done, situations of generalized violence? Is such a classification useful when trying to assess the protection needs of people fleeing such situations and determining whether or not they are refugees? I think it's not useful to classify situations as armed conflicts or as generalized violence. First of all, classifying a violent situation as an armed conflict does not inform the asylum adjudicators of the facts and circumstances on the ground. An armed conflict may exist without showing any signs of violence, and equally a situation may be very violent despite having not been classified as an armed conflict. And secondly, classifying a violent situation as an armed conflict can be a distraction. For lawyers, the classification of a violent situation as an armed conflict has the problematic effect that it draws the discussion into the arena of international humanitarian law, or IHL, the law of war. However, for the purpose of inclusion of refugee protection, IHL, international humanitarian law, is irrelevant. To determine eligibility for protection, including refugee protection, a clear understanding of the situation from which people have fled is essential. Armed conflicts and other situations of violence have changed. It involves a variety of actors, of methods and of means of warfare, resulting in a variety of effects, impacting increasingly on individuals and those who are not taking part in the fighting. It's important to understand the causes, the characters, and the effects of violence in order to understand the international protection needs of people fleeing them. The challenge, I guess, for asylum adjudicators, asylum decision makers, and judges is how to read armed conflict and other situations of violence for the purpose of applying international protection, in particular the 1951 refugee definition. And I think in general one has to look at three indicators, for lack of a better word. First of all, one must look at the causes of the conflict or the violence. Secondly, one must look at the character of the conflict or the violence. And thirdly, one must look at the impact or the effects the violence has on the people. I will not go into too much detail on these three indicators, but I would like to refer to a study that UNHCR has commissioned and has been conducted by Professor Theo Farrell and Oliver Smith of the Department of War Studies at King's College in London. The study was recently published in UNHCR's Legal and Protection Policy Research Series and is available on the web, both through UNHCR's public website as well as in UNHCR's database called RefWorld. I can show it to you, this is the study. The paper critically reviews the scholarship on the causes, the character and impact on civilians of armed conflict situations and employs a qualitative analysis of 6 case studies. It looks at Afghanistan, Colombia, the Democratic Republic of the Congo, Mexico, Somalia and Sri Lanka. And the paper makes clear that armed conflict and other situations of violence involve a wide variety of motives, of actors, of modes of violence, and all of which can be relevant for determining and applying the 1951 Refugee Convention. For example, the conflict may be grounded in ethnic or religious differences. Children are used as soldiers, and rape is a weapon of war. All this may relate directly to whether or not the 51 Convention applies. The effects of the conflict and violence are multiple, showing both direct effects as well as indirect effects on the population, ranging from deaths to population displacement, to food insecurity and to ill health. Just a few remarks on classifying a situation of violence as one of generalized violence, which is not unproblematic in my view. Such a classification implies that the violence is unlimited, is untargeted, is widespread, and affects many people indiscriminately. While situations of violence undoubtedly involve violence that is indiscriminate in its effects, the concern is that with such a classification, it draws attention away from applying the criteria of the 1951 Refugee Convention. And in fact, that many people fleeing situations of armed conflict or other forms of violence are in fact refugees because the violence is discriminate. And the word discriminate is the defining element when it comes to applying the 1951 Refugee Convention, meaning those who risk harm on some discriminate basis have a right to be protected as refugees. Now, a second study has been commissioned by UNHCR, which will look at how states have applied the 1951 Refugee Convention in determining eligibility for refugee protection. While this study has yet to be published, it shows that states struggle with a number of legal questions. And I will briefly point you to 4 of these legal questions. First of all, situations of conflict and violence raise the question of how to determine whether an individual has a well-founded fear of being persecuted when a large number of people are similarly situated and are at risk. It's the question of how personalized or how individualized the risk must be under the 1951 Convention. According to UNHCR, there is no need for a person to be singled out or being individually targeted, nor is there a requirement that he or she suffers from a risk which is different or higher or bigger from other persons. It's also irrelevant whether the group that is affected by the violence is small or large. Whole communities may risk persecution for convention reasons. The fact that all members of a community are equally affected or at risk does not in any way undermine the legitimacy of any particular individual member of that group. The second question that states struggle with is situations of conflict and violence raise the question if the concept of persecution is the same in situations of war as it is in situations of peace. In other words, is the threshold of what amounts to persecution not higher when it comes to a situation of war? For example, in situations of armed conflict, international humanitarian law applies and allows for certain conduct that is not allowed in times of peace. Another example, and this is taken from a court decision in the US Circuit Court of Appeals, in times of conflict, the awful becomes ordinary, and the level of severity, what constitutes persecution, rises. In UNHCR's view, there is no difference between times of war and times of peace for the purposes of determining what amounts to persecution within the meaning of the 1951 Refugee Convention. The third legal question deals with construing the nexus, the causal link between the convention grounds and the well-founded fear of persecution. In a complex situation of conflict and violence, the intent or the motive of the persecutor is often difficult to establish. It is therefore good to be reminded that the nexus between the persecution feared and the convention grounds refers to the refugee's predicament rather than the persecutor's mindset. Of course, the nexus can be found in the motive of the persecutor, but this is not a necessary requirement. A nexus can manifest itself in the underlying reasons of the conflict, in its characteristics, or in its effects. And a fourth legal question that the study deals with is the question that deals with finding the convention ground. This may be less problematic in situations where the conflict is grounded in ethnic or in religious differences. In such situations, the ground may be easily found in race, nationality, or religion. But more problematic is it when situations are not clear-cut along religious or racial lines, and when the violence, when the victims of the violence are certain professionals, or even more broadly, when most of the victims of the violence are civilians. Can they be identified as a particular social group? Can certain professionals, for example, health professionals, doctors, be called a particular social group? Or even more broadly, can civilians be identified as a particular social group? There are other legal questions relevant when it comes to applying the 1951 Refugee Convention to people fleeing armed conflict and other situations of violence. I had a discussion earlier today about state protection. And then there are numerous questions relating to evidence, to the burden of proof. The two studies that I've referred to so far are, as I mentioned, part of a project that UNHCR is undertaking. This project includes 4 other studies, which are currently being undertaken. Study 3 and 4 deal with the 2 regional refugee law instruments that both extend the definition of a refugee to include people who flee events seriously disturbing public order or situations of generalized violence. The terminology event seriously disturbing public order is part of the extended definition in the 1969 OAU Convention applicable in Africa. And the terminology generalized violence is part of the extended definition which we find in the 1984 Cartagena Declaration. Study 5 deals with complementary forms of protection as developed under international human rights law, and Study 6 deals with specific gender-related issues. All 6 studies will be finalized in September of this year, after which UNHCR will organize an expert roundtable. Studies, together with the conclusions of the roundtable, will then feed into the drafting of guidelines for the protection of people fleeing armed conflict and other situations of violence, thereby looking at the 1951 Convention first and foremost, but also looking at the extended definitions in the 2 main regional refugee law instruments, as well as complementary forms of protection. A final question that I'd like to pose to you is, why focusing on the primacy of the 1951 Convention? Well, it's our main document. But that doesn't answer the whole question. When I recently attended a seminar in Europe with experienced European lawyers, and when I look at a study that the UNHCR's Bureau for Europe done last year on how the European Union Qualification Directive is used in Europe, and the 1951 Convention is not used in Europe when it comes to people fleeing conflict and violence. I was kind of worried to see that lawyers tend to not use or not want to use the 1951 Convention for their clients. And the reason for that is, well, it's easier to classify a situation as generalized violence and then have people be protected under complementary forms of protection, in Europe being subsidiary protection or sometimes national complementary forms of protection, humanitarian asylum, or whatever the word for that is. It is much more difficult for lawyers to go through all the elements of the 1951 Refugee Convention and then claim that the person is a refugee. And why bother to go to the Refugee Convention? In countries in the European Union or in countries in North America, the rights attached to complementary forms of protection are the same as the rights to attach, roughly speaking, to refugee status. So why bother for my client to make it more cumbersome? Well, the focus of the primacy of the 1951 Convention, I think, has to be re-established. First of all, it's the only instrument globally that attaches specific rights to people being refugees. And the 1951 Convention is as effective as today as it was 61 years ago. Moreover, as soon as we go into the direction of complementary forms of protection, we lose sight that in many parts of the world there is no complementary forms of protection, and the only instrument that we do have is the 1951 Convention. And states in those parts of the world are actually looking at Europe, are looking at North America, and how restrictive they are in applying the 1951 Convention. I'll leave it at that, and I hope to have a fruitful discussion with my experienced Canadian counterparts. Thank you.
This is going to be an even more exciting session than I thought, because we've got a gauntlet thrown down. We were talking before the panel started about judicial activism. This is a form of institutional activism, legal activism, going back to the original definition, wanting to read into that definition or interpret that definition in a very wide sense, and doing the scholarship that will give the ammunition to broaden the scope of it. I think if it works, it would mean over half the refugees would suddenly become convention refugees rather than under 10%. So it's a big implication. Barbara?
I mean, I'm not sort of giving a speech, I'm just making comments about some of the issues, right? I think that if one talks about judicial activism in Canada today in the context of refugees, it's not rights enhancing, it's rights defeating. For overall, there are some good decisions. I think in terms of the issues you raised, we have a very weak situation outside of the definition of a convention refugee, because we have two definitions that are used. One is the convention refugee definition from 1951, and I do think that there is jurisprudence going back to the old Federal Court of Appeal that can and should be used to try and maintain the broad approach that's been taken to an interpretation of the definition. I don't think that approach has been adopted by the Federal Court or the Court of Appeal right now, and that's one of the things I want to talk at the end. I don't think you go to the Court of Appeal with some of these issues unless you want to go to the Supreme Court of Canada, because you're going to lose in the Court of Appeal, I think, on almost all of them. So we have the convention definition. The other definition, which should be the one that covers the gap, people who are at risk of torture or cruel treatment, only applies to persons who are not at generalized risk. So if everybody else is at the same risk as that person, then they don't come within that definition. The other mechanism that we've always had has been the humanitarian compassion application, in which the general, broader concepts of risk would be addressed, and this government just took away risk from the humanitarian compassion definition. I mean, there are efforts now to sort of put it back in other ways, trying to hide it as you make the submissions. But it's clear the government did not want anything broader than what we already have. In fact, they're trying to cut back on the broadness. And then the last sort of provision that the government has, which is rarely used now and used to be used in the past, was no deport policy. So right now, because Syria is such a mess, there's a no deport policy for Syria. That's temporary. It doesn't assist people, even if the no deport's in place for a number of years. They then have to make a humanitarian compassion application. So having said that, we have no real strong mechanism for helping people who are at risk of quote-unquote generalized violence. I agree with, I think, the input, I mean, what's been said by a couple of the authors is that it's not usually generalized risk. And the problem with the court right now about how they look at it is, if you take the example of Sri Lanka, because we have lots of Tamils coming to Canada, the generalized risk category, the person in need of protection, the way judges are often looking at it now is if there's beyond a critical mass of Tamils that are at risk, it's no longer personalized risk. It may be that your group, they're after your group, but if it's broad enough, then you don't come under the cruel and unusual person in need of protection category. That's wrong, and I think that's wrong in light of the old jurisprudence of the Federal Court of Appeal. And I just want to talk about a couple of cases which I think anyone practicing really needs to emphasize, because first of all, it's binding on federal court judges, most of whom know nothing about refugee law. If they do know about it, they've learned about it since they became judges. And many, I don't think, know much about law, generally. No disrespect, Justice O'Reilly, I'm not talking about you. But I do think that there's, in this area of administrative law, there isn't a strong grounding of jurisprudential background of many of the judges. But there are three cases in particular. Salibian from the Federal Court of Appeal, where the Court of Appeal essentially said, if the bullet has your name on it, you're a refugee. If the bullet has the name of your group on it, you're a refugee. If the bullet has no name and it's just flying around, you may be a person who needs protection, but you're not a refugee. It's the bullet with the name of your group on it that's the problem today. And Salibian is really important to keep reminding the court in cases that if the bullet has the name of your group on it, you're a refugee or a person in need of protection. Early on is a decision, again, of the Court of Appeal. I can't believe I used to criticize these judges. I mean, they're wonderful when you look at it. With the passage of time. No, we had a bad week this week with the decisions from the federal court. It always depends on who the judge is that week. But in any event, in orally on, the Federal Court of Appeal, I think this is Justice Mahoney, who says, one only has to recall the recent history of Cambodia to recognize the possibility of widespread persecution of its general population by a national regime. With respect, it is not axiomatic that nationals of a country who escape that country may not have a well-founded fear of persecution by reason of their nationality should they be returned. So they adopt a very broad approach. If you're at risk because you're national of that country and they're just killing nationals indiscriminately, you're at risk going back and you may very well be a refugee. The group claimed in Orleans was the poor and disadvantaged people of Haiti. And then the last one in terms of this is the Zazali case. Again, it's Court of Appeal, and it might be Justice Hubison, I think, who wrote the reasons. Justice Dick Harry wrote the reasons. In any event, that was one where Lebanon was in a civil war, there was no state, and it answers the Somali issue, I think, because what they say is it doesn't matter that there's no state. Again, if the bullet has the name of your group on it, it doesn't have to be a state actor. It can be anybody who's after you. And so Zazali is also a really important case. And then the nature of persecution, again, I think if you go back to the old Federal Court of Appeal cases, these are all from the 80s and very early 90s. The Rajadine case says persecution is systemic infliction of threats and personal injury, harassing or afflicting with repeated acts of cruelty or annoyance, to afflict persistently, to afflict or punish. It's for the people who have, like, again, if you look at the Tamils, internal displacement for years, for decades, the fact that they can't get health care, the fact that they're harassed, that they have to pay bribes in order to get out of detention. I mean, there are board members who say that's not persecution. Using these old definitions, that is persecution if it continues over a long period of time. And then Suraj Pal follows the same principle and applies it actually to Sri Lanka in the context of the situation in Sri Lanka at that time. So I think that the tools are there in our jurisprudence, in Canadian jurisprudence, to keep pushing for a rights-enhancing interpretation of the refugee definition and the definition under Section 97, the person in need of protection who's at risk of cruel treatment or torture. And I guess those are the... I know what I was going to say. I was going to say that I think what's important is to use the old case law. I think it's really important to try and build up a body of law in the federal court before trying to get it certified in the federal court of appeal, because the federal court of appeal is not a rights-enhancing court. It's just not. I'm sorry. It doesn't look at these issues as though human rights are significant for the most part. It's not what you'd call a court that relies on jurisprudence in the past. It makes up case law as it goes along. It may be because of the backgrounds of some of the judges coming from Quebec, which doesn't rely on jurisprudence in the same way as the British tradition of common law. But I think it's got to be sort of strategic, and what you would eventually want to do is get up to the Supreme Court of Canada and have them settle this issue in terms of the broadness of it. Thanks.
Thank you very much.
Thank you very much. So my role here is to take the NGO position, the non-lawyer stand on this. So I want to start by asking a little bit what kind of sense all of this discussion makes to the general public. I don't know about the rest of you, but I find talking to people who are not in the refugee field, not expert on refugee law and things, their sort of prototypical image of who the refugee is somebody who is fleeing a war. And you often get yourself into a kind of strange conversation where, you know, yeah, of course these people fleeing the war, of course, you know, we should protect them, but I'm not so sure about these people fleeing on the basis of sexual orientation or gender or whatever. That doesn't make sense to me. And you're then forced to say, well, actually, the second category is a refugee, but the people fleeing war, if, as Barbara says, the bullet doesn't have their name on it, they're not, in fact, a refugee. In this context, we're particularly, political context, we're particularly conscious of the need for public support to sustain the refugee system, to sustain Canada's commitment to refugees. And so I asked the question about how we pursue this conversation, both the sort of risks that are involved, but also the opportunity, because when you have a population that generally figures that people who flee war should obviously be first in line to receive protection, how can we make use of that popular position? The second point I wanted to make was in relation to the moratoria. Barb mentioned briefly the somewhat inadequate provisions that we have that come the closest to giving, in name, some level, minimal level of protection for people who are fleeing a war without meeting the refugee definition. So Canada has had this for many years. The current version of it is in Section 230 of the regulations. And this is the US definition of temporary protected status, which works slightly differently in the US, but we have just taken, I don't know quite why, I've never figured that out, but we've just taken over exactly the US wording. So this provision gives the minister, which is now the Minister of Public Safety, the ability to impose a moratorium of suspension, temporary suspension of removals for where there are circumstances in a country or a place which pose a generalized risk to the entire civilian population as a result of armed conflict. So the first provision is relating, there's a couple of others, but the first one is relating to armed conflict. So this is the place where what Kees was talking about in terms of complementary protection. In our situation, it's much weaker, but that's the closest that we get. in Canada. There are a number of problems with this provision. The first of which I highlight is the issue of how the decisions are made. So this is not a tribunal that is saying, okay, this situation applies to you. No, this is a minister who decides to declare a temporary suspension of removals for a specific place, or to lift that temporary suspension of removals. And there's no way really that you can force the minister to make a decision. So the Canadian Council for Refugees has for many years been saying, well, it seems to us that Somalia is the sort of place where you shouldn't really be sending people back. And in fact, in Europe, that seems to be quite widely understood that the situation in Somalia is such that you wouldn't send people back. But so far, Canada has not gone ahead and imposed a temporary suspension of removals for Somalia. One of the problems that we find, the Canadian Council for Refugees has been involved in this process for a number of years. We've actually technically withdrawn from it the sort of reviewing of the countries that are have a temporary suspension. But one of the problems you face is that there's a sort of division between at the refugee board. So the section 96, 97, the refugee definition, the extended protections that Barb mentioned, there it's all about, making sure you're not just one of the general population. So you have to highlight in that country, these are very specific, targeted places, targeted violences. Where you're coming to argue for temporary suspension of removals, there you've got to do the absolute opposite exercise. And there you've got to say, well, no, we're not going to mention the fact that camels are particularly targeted, or this ethnic group, or women are particularly targeted, because that's not the entire civilian population. So you've got to emphasize the indiscriminate nature of the violence that's occurring. The third perspective that I wanted to, just in terms of finishing off on the moratoria, the fundamental issue, which is obviously different from in Europe, is that the temporary suspension of removal simply means that you are not currently subject to removal, and you should, without too much difficulty, be able to get a work permit. But other than that, you are basically in Canada without status, with all that that entails, unless you can finally get status through humanitarian compassionate grounds, which is often a very difficult path to take. I wanted to say a few words about also how all of this looks from the point of view of refugees, or people who are seeking refugee status in Canada. Just as the general public has only a vague understanding of what is involved in being a refugee. Of course, people who flee don't generally consult the legal manuals or get legal opinion before they say, well, let me take my chance for life and flee the current situation of violence. For refugees, the whole categorization process that we with our legal processes put them through is often profoundly distorting. And I want to highlight also how in a lot of the discourse there's this sort of moralizing element that comes along with it, whereby the implication is that if you fled as a refugee and meeting the refugee definition, then that is justified. But if you made the big error to escape with your families because you didn't want to be shot by that bullet, which didn't have a specific name on it, but was nevertheless heading for you, that is somehow putting you in the category of morally a suspect person who has contravened different various rules that we can't support. The situation, and I think some of the papers that Kees was talking about highlight how what we're tending to see a lot today, and maybe more than in the past, is how conflicts change in character, becoming less of the traditional war situations and more kind of criminal violence, equally deadly potentially for the people that are suffering it. But Colombia is perhaps an example of where, for many years it seemed to be, at least in some respects, a fairly clear war between different factions. Now that phase of the war is over, but the people that were the players in the past have now, signed up under a different name, which may be just the name of criminal activities. But for the people that are at the victims of the violence, nothing much changes, except that potentially, depending on the analysis, depending on how the definition is interpreted, they can find that they are out as the rejected refugee claimants because they're more likely facing criminal violence. And I just want to finally comment on how also the need to categorize, to give the reasons for your flight for a refugee are often, and I think those of us who have spoken to many refugees see this, is it goes against the tendency, the will for various reasons for refugees not to want to identify, pull themselves out of the crowd, not to want to be particular, not to want to be targeted. And in fact, it's a rather paradoxical that the people who have been at risk because they've been targeted, we now have to ask them to heighten and to highlight the fact that they are targeted in order to get protection in a Canadian context or in a country of asylum. Whereas for many refugees, the instinct for a variety of reasons may be to want to fade into the background, to be as anonymous as possible, and to fly under the radar.
Thank you very much.
James, I hope you enjoyed the temporary elevations. Good morning. I will call on James now.
Thank you very much. Thank you, James Simeon, for the invitation to speak again. He very cleverly put together this panel by telling all of us that we didn't have to make any kind of formal presentation, so we all just showed up to comment on one another's comments. So I don't have very much to say, but I'll start off by pleading guilty to Ms. Jackman's accusation of an absence of background in this area of the law.
But I didn't mean it.
Yeah.
Just so you understand.
But even worse, it's true of me. Some of you who were here the other day would have heard me say that I graduated from this law school almost exactly 30 years ago. And for the ensuing 20 years, I kept my ignorance of immigration and refugee law completely intact. And then I was appointed to the federal court, and for the past 10 years have been sort of a fair to middling student of immigration and refugee law. And this week has been an immersion course for me, and I've enjoyed it very much. In terms of my own remarks, just a couple of things about how these issues have presented themselves in front of me, and I must say it hasn't been frequently, but it seems to be becoming more frequent, I think, in terms of the issues that are rising under Section 7 of the Immigration and Refugee Protection Act, as referred to by Ms. Jackman. But under Section 96, I've had a couple of situations where I've had cause to wonder about how to apply the concept of generalized violence to an individual claimant. I had one case that I recall where there was a claimant from Haiti, and the evidence was that this female claimant had been subjected to robbery, extortion, kidnapping, and sexual assault. And the position of the Minister for Citizenship and Immigration was that this was just a situation of generalized violence. Lots of people in Haiti are subjected to similar forms of victimization, and so there's no basis for a claim under Section 96. And the thing that caused me to worry about that position was that the last part of what I described as that series of offenses, and that is sexual assault. So I put the question to this particular council: suppose we were talking about a Roma claimant from Central Europe someplace, and we were talking about situations where there was a great deal of crime, and in particular that many homes are broken into and things are stolen. And we had a Roma family come to Canada who claimed that their home had been broken into and things had been stolen, but then their house was burned down. Would you not be able to claim that there was a nexus to a ground recognized under the 1951 Convention because there was a particular form of mistreatment of this family that was not part of the generalized violence in that particular area of the world, and therefore, wouldn't you therefore say of this woman from Haiti, if she was subjected to the ordinary forms of violence, all right, but the additional factor is that she was additionally subjected to sexual assault. Wouldn't that mean that she was the victim of persecution on gender grounds? And the answer I got, which I found troubling, was that that was all just generalized violence and I needn't worry about it. Well, in that particular case, I decided the case on other ground, but it has troubled me since that would be what Canadian law would recognize. I know there's some support in decisions of some of my colleagues that would suggest that my discomfort would be shared by them and that they would be willing to make a finding of a well-founded fear of persecution in that situation. So that's the Section 96 context. In terms of Section 97, which is, as Jackman says, excludes risk that's faced generally by other individuals in the country. We're getting a lot of cases in the court coming mainly from Central America where people are subjected to gang violence and organized crime offenses. But in this, with respect to 97, we don't worry about any kind of nexus. It's not tied to the 5 grounds under the 1951 Convention. So that's not the worry. The worry is whether the situation comes within a generalized risk faced by other individuals in the country. And these, if you look at them, are cases that seem to be fairly fact-driven. They come from Mexico, El Salvador, Honduras, Guatemala, etc. But I had occasion recently to try to go through to sort out what was going on. I think if you went through them, you might wonder why some judges were recognizing a claim under 97 and some not, or to be more specific, were allowing judicial reviews or dismissing them, as the case may be. But I think if you look at them closely, you may see a couple of things arising that would be important considerations for the decision maker, the first instance decision maker, or for the court on judicial review. And that is, the first one might be whether the individual has been targeted for a specific act. So in situations where a person has been targeted because they've made a complaint to police, or they were a member of an anti-gang task force, or they ran a particular kind of business, that might suggest that it was more than just a generalized risk faced by other individuals in the country. Another consideration might be whether the agents of persecution, to use that term in this different context, is actually identifiable. That is, whether someone has been harassed by anonymous gangs or has been receiving anonymous telephone threats might suggest that this is a generalized risk because we don't know why this person or persons might be pursuing this family or this individual. So the ability to identify the persecutor would be important in many cases. The third is whether the targeting has been going on over a significant period of time. So if it's a one-off kind of thing, you might think that it's just part of the generalized violence in that particular jurisdiction. But if it's sustained, it might cause you to think that the individual or the family is actually being singled out and that it's not a generalized risk. In my own cases, I have to say I thought about it in terms perhaps more of a threshold. I've had cases where it seems like someone was targeted simply because, let's say, he was a merchant and gangs were going after people who had any kind of money or had some kind of visible cash flow, were visible because they were street vendors or operated a market stall or a small shop or whatever. So So at the beginning, it seemed like it might well be just part of generalized gang violence in that particular jurisdiction. But as time went on, the facts might show that the individual is being called by name, being called at the home, being told that the gang members know where the target's children go to school. There have been threats of kidnapping. There's been specific fine, so to speak, that's been imposed on the family for resisting the threats that have been made to them. There have been, let's say, a family member who, against whom there was an attempted kidnapping and so on. If you look at some of these scenarios, there's an escalating scale of violence, and it seems to me at some point you have to say, well, this has become personal. You know, the person is not just randomly selected as being someone who might have some money of interest to the gang, but they're being singled out, and that's no longer generalized violence. So as a reviewing court, it's this kind of analysis that we might hope to see by the decision maker, whose decision we're looking at, whether it's a pre-removal risk assessment officer or it's the IRB, that whether they've given consideration to the possibility that this is a targeted family or individual, and not just said, well, this is about extortion, that's crime, everyone's at risk of being a victim of crime, and left it at that. So it seems to me that's the kind of inquiry that we should be looking into, and I have the sense that that's where the law is evolving. So those are my unprepared remarks.
Thank you very, very much.
Could you get the mic?
I'm going to ask Kees to respond because what we have is a situation in which you have some ammunition now on your side by Barbara referring to a number of early cases which have support your position of the early interpretation of the 51 Convention, but the paradox of evidently the judicial system ignorant of their own background, at least alleged. And Janet's point that the paradox of the public who understand refugees in one sense, the non-convention sense, rather than the convention sense, and the paradox of going to make cases in which you have to do this kind of dichotomous choosing, either try to make a case for indiscriminate or for discriminate, depending on what you want to fall under, which doesn't help your judicial activism from the institutional basis. James's own comment on his own experience of really trying to, in practice, be a judicial activist by pointing out agency, pointing out particular kinds of things like rape and sexual discrimination, and trying to find levers to hang the convention on, which will expand the definition in this kind of way, but with all the difficulties attached to it, especially if in fact you have the dilemma of which grounds do you go before, and the dilemma also reinforces conservatism in interpretation. So I invite your response. I thought they were very good comments.
No, I want to thank all three speakers for their reflections on the issue. And it certainly gives me a lot of food for thought, and UNHCR a lot of food for thought on how to pursue this further, and including how to pursue it beyond simply preparing guidelines, because that's one thing we can do, but then the next thing is how to make sure that these guidelines are used and implemented in a way that we think they should be. Just a few brief remarks. It's interesting if you look at the study that the consultant has done on how the 51 Convention has been interpreted and applied in various jurisdictions, and she looked at a whole range of countries, and it's, the broad message that you get from that is that many jurisdictions go back and forth. You have old case law that says A, and you've got newer case law that says B, but then you've got even newer case law that says C again. And then it's a matter of, yeah, what do you use and how do you use it? So that's interesting. And of course we will use the jurisprudence the way we see fit. We will do a pick and choose. I mean, I'll be honest about it. Of course, we will do that. But for us, the important point is that, as I said before, and that is maybe judicial, well, not judicial, but it's an activism on our end. It is looking at the 51 Convention as what's in the European Court of Human Rights terms, looking at it as a living instrument. We are confronted with people being displaced because of a conflict going on, because of a violent situation going on, and we would like to see that these people are recognized as refugees, because first of all, we believe that they are refugees, they are falling squarely within the definition of the 51 Convention, but as you pointed out, the popular perception is equally so. They are refugees, so why not protect them as refugees? And that's an interesting argument that I think UNHCR has not been using that well, or hasn't been using it at all in the past, and maybe we should use it. I guess, and I'm being frank here, that our PI line is not as good as it sometimes should be. One example that relates to the remark that you made about the refugee or the asylum seeker coming in with a claim, with an account, and then that account needs to be assessed, both in first instance as well as all the way to the courts in judicial review context. And I've used this example before. A doctor from Iraq claiming asylum, saying, I've fled because 2 weeks ago the hospital that I worked in was attacked. Unfortunately, or fortunately, not many people were hurt by it, but I felt that the danger being too big, and I had to go. That's the story. What do you have? You don't have a lot to go on. I mean, it wasn't a personalized attack. You were not targeted. But if you then continue and you ask, of course, so where do you come from? Well, I come from the city of Kirkuk in Iraq, in northern Iraq. So what ethnicity do you have? Well, I'm a Turkmen. Okay, does that give you much more? Well, at least you may have some kind of information that can link it to the ground, but you still don't know a hell of a lot more, and you still have only this attack, basically, that it uses. But if you then look at country of origin information, and you see that Turkmen are more often the targets, or the victims, not the targets, but they're the victims of violence. And why they are the victims of violence? If you dig deeper, they are the victims of much of the violence by criminal gangs, because they are considered to be the most wealthy members, most wealthy population in northern Iraq. So these criminal groups target Turkmen in particular, and not just Turkmen, but they particularly like doctors, because there's perception that doctors are even more wealthier than Turkmen. So I mean, gradually you're getting more and more information that distinguishes this individual from other individuals, and you're slowly getting to I think an assessment and an account that allows you to apply the 1951 Convention. And I think the final remark I want to make is going back to this conception of generalized violence, or this idea of generalized violence. And to me, it's absolutely not useful to classify a situation as generalized violence. And I'm using, I guess, Somalia as an example. I mean, the situation, as you all know, in Mogadishu in particular, is pretty dire, and violence is everywhere. There are bullets with names on it, there are bullets with no names on it. But you see a tendency, particularly in Europe now, and I can't speak for other parts of the world, where, okay, that situation is now classified formally almost by the European Court of Human Rights in the case of Sufi and Elmi. Mogadishu, the situation in Mogadishu is one of generalized violence. The level of violence is so intense that no one can be returned. The consequence of this is that people fleeing from Mogadishu, I mean, they do get protection, but they get protection from Fumar. They are not returned. They may get subsidiary protection under the EU Qualification Directive if they apply for asylum in an EU member state. But no one is looking at their refugee claims anymore, and if they should be protected as refugees. So I think there's a big danger in jumping too quickly to this generalized violence idea.
Sure.
You know, I really think, like, I don't know if people have read Hudson, but he was the first sort of, I think, real jurist who dealt with the definition of convention refugee. And if you look at it historically, social group is broad enough to catch all sorts of people. It's not broad enough in Canada. They narrowed it so much. But originally, people fleeing communist governments were basing their claims on class and ownership and property ownership and the fact that they were business owners. That's what it was meant to protect. And I don't know why when you talk about Mexico or places like that it isn't broad enough to catch the definition itself. I'm not talking about Section 97, person in need of protection ground, but the convention definition should be broad enough to catch people, even if there's no bullet that has the name of your group or yourself on it. If you're part of a class that's going to be targeted, it's got at least the name of your class. I think that counts.
I want to open it up to the audience for a few minutes. We have 10 minutes left. If you want to make a brief comment or ask a question, if you can come to the mic, introduce yourself, raise a question, and we'll take 3 or 4 questions and then have final comments by the panel. Anyone will raise a question, make a comment? Go ahead, join the line. It's always the first one that's difficult. Then you get to be sorry that you didn't line up at the beginning because you don't get a chance to ask a question. Go ahead.
Hi, thank you very much, first of all. I'm not a legal scholar or even a law student in any shape or form, so I thought the presentations were very interesting and certainly very informative. My name is Laura Robbins, right? I'm a doctoral student at the London School of Economics, and I just wanted to ask a question that came to mind from Janet's comments and then just picking up from what Kees mentioned. Regarding the temporary stay of removals, how can we square those kind of developments, at least in the Canadian context, with the recent removal or the recent elimination of the country of asylum class? Obviously, temporary stay of removal doesn't confer any status, as Janet was saying, but at least from my understanding, it seems that the fundamental logics in terms of providing some sort of recourse or protection in the case of the country of asylum class to people fleeing situations of generalized violence is fundamentally the same. And so I was just curious for your thoughts about that. Thank you.
Other questions or comments? Don't wait to sit in your chair. Save time and come to the microphone now. I'll recognize you at the microphone. So if you want to ask a question, you better be at the microphone next time.
My name is Mahdi Rizvi, and as you know that after the Afghan invasion by Russia, millions of refugees, they migrated to Pakistan and neighboring Iran. Many of them went back. We know the political situation there, but millions of them, they settled in Pakistan, and you know the situation in Pakistan now. So is there any law which can send them back?
Not called the right of return, it's an obligation to return. Any other questions or comments? We'll get to the questions in a minute. It's your last chance. Going, gone. Okay, final comments from each of our speakers. Can we start at this end? James first. You want to handle either of the questions or both? Joe, what did you want to say?
Well, actually, I don't have a lot. I don't know much about the Iranians and Pakistan situation. I think Kees is the best one to probably deal with that. But the country of asylum class, I think, is just another indicator of what our government is doing, which is trying to narrow who gets protection. And there's a case going to the Supreme Court of Canada, really. It doesn't have to do with, it has to do with people who are excluded from protection, but it's the same kind of principle on how the government is restricting what powers there are in the legislation to try and make sure people do not get protection. So by calling everybody from a country where there's a popular insurgency, by labeling them all as terrorists, we don't have to land them. That's another way of getting rid of group claims, is just call them all terrorists. And I'll tell you, I think if you did an analysis of all the different countries post 9/11, you'd find Canada probably leads them as the one most likely to label innocent people as terrorists, and then not let them become permanent residents of Canada. That's going up. But again, it's all a matter, I think, of how the government is explicitly, deliberately trying to take away the rights that we recognized for a long, long time. And what's really upsetting about it is that it's all being done without a whimper, you know? Like, if you give an example, humanitarian compassionate discretion, we've had a general discretion to allow people to remain in Canada since we got legislation in 1910. There has always been a discretion. This government is eliminating it for classes and classes and classes of people. They've already started on inroads to the humanitarian compassionate discretion, and they're just going to, in the legislation that's coming, they're taking it away. They're just forcing us into charter arguments. That's what they're going to end up doing. Anyway, sorry.
Well, just explain briefly for those of you who are not familiar with it. The country of asylum is a category in the regulations which gives, in brief, a sort of broader refugee definition that is only open to refugees that are resettled from overseas, and more specifically to privately sponsored refugees. So groups in Canada can have a refugee or a person who doesn't meet the refugee definition but is personally affected by, for example, a situation of war, to be resettled. This definition, I think the reason why we have this overseas and not in Canada is because the overseas refugees are generally, within the scheme of things, looked at, as we all know, as more desirable, and we can afford to be more generous because we only bring those people that we choose to bring. We have had the same issue that Kees was talking about in Europe, whereby decision makers go with like the easy complementary protection rather than the CR definition. Something that we've complained about frequently is that visa officers faced with a privately sponsored refugee, for example, an Afghan refugee in Pakistan, they'll just say, oh, well, we'll call the country of asylum, even though the person may have a perfectly decent refugee status. The opposite situation that we have in Canada with the temporary suspension of removals is I think is designed in a reluctant sort of way, but as a recognition that people that are here, if we're going to deport them, then Canada is going to be responsible for sending them back to a situation of war. So the government over the years has constantly found that there are situations where they don't want to be going against their own conscience, but also presumably popular opinion, of sending someone back to face to a situation of war, because it just seems so improper. Whereas somebody who is overseas, it's not Canada that's going to send them back to anywhere. All we're going to do is say, sorry, you've got to stay in wherever desperate situation you are, and you may be returned, but we're not going to be the ones that are actually putting you on the plane and sending you back to a situation of war. But I agree with Barbara that times when we saw room for expanding definitions and being more generous with definitions, that's not where we are right now.
I'm going to give the last word to Kees with the question that here you have the paradox of UNHCR now really pushing for really breadth for the definition of the concept of refugee when the government, in one of the most generous countries in the world, is pushing for narrower and narrower interpretations, and that kind of paradox. The last word now for the week. Thanks.
Before going briefly into the paradox, I'm sorry that but I honestly don't feel equipped to either answer your question or your question. But on the Iranians in Pakistan, whenever there's talk of return, and again, I don't deal with that area, I have no expertise in that area, but whenever there's talk of return, I hope that it will be voluntarily, truly voluntarily. I think that's the fundamental basis for it. On the paradox, between restrictive policies and restrictive laws being implemented, and not just in Canada, unfortunately, but in many what we tend to call sophisticated jurisdictions. I guess we rely on, and I go back to your first comment, on judicial activism. We're relying, honestly, we rely on the courts then to uphold a true interpretation, application of the 1951 Refugee Convention. Whether it's in relation to people fleeing armed conflict and other situations of violence, or whether it's in relation to people fleeing because of their sexual orientation or gender identity. And we've had successes in that regard, and because we are dealing with more restrictive governments, we do have a more strategic and proactive approach when it comes to taking these cases to court, either directly, in the sense that we as an organization intervene in cases, or through lawyers, by assisting lawyers in strategic litigation efforts. And I think that's important for us. And it's probably there will probably come a time where governments, I hope at least, will open up their policy again, and where we do not have to go to the courts. But right now, I think we have to go to the courts. At the same time, it's also, when it comes to take it back to this topic of people fleeing conflict and violence, it's also important to acknowledge that, no doubt, there are situations where people truly flee the indiscriminate effects of violence, and that they are not refugees, but nevertheless, because they flee a pretty violent situation, should be protected, but maybe they're not as refugees, but on a form of complementary protection.
With that, I want to thank the panelists, and thank you, and thank the organizers, and call the session over. Thank you very much.